Thank you, Erin. All right, so it is my honor to introduce our last speaker. Before then, we'll move to the panel where you get to hear from everyone and be in conversation with everyone at once. And now we're going to turn our focus to something that we have been talking about all day, but around the edges, right? And we'll talk about it more. We're going to talk about the threatened erosion of international law and human rights. And we have the perfect person with us to talk about it. Professor Susan Akram is a clinical professor and director of the International Human Rights Clinic at Boston University School of Law. She has worked for 3 decades on immigration, asylum, refugee law, forced migration, and human rights, and has advocated for forcibly displaced and stateless communities. Her research and publications focus on those topics with an interest in the Middle East, the Arab and Muslim world. She's been recognized as a Fulbright scholar, and she's lectured on Palestinian refugees to general audiences around the world, as well as to committees of the United Nations, including the High Commission for Refugees and the Relief and Works Agency for Palestinian Refugees, the European Union, and many other bodies. So join me in welcoming Susan Akram.
Thank you so much. I'm fighting a very bad cold, so hopefully I'll be able to get through this without losing my voice. I want to thank everyone for this amazing gathering, the main coalition for Palestine, and especially Fateh, for pulling all this together, and of course the First Parish Church for rescuing us. I'm going to talk about international law and human rights. Thank you so much. But looking at it through the three major players that we have been considering, but looking at them in relation to international law. And what does international law have to do with anything? Today is, of course, the debate that I have with my students all the time. I think of Palestine as the fault line of the world's conflicts. And I think of the Palestinian refugees as the fault line of the Israel-Palestine conflict. I'm not going to talk specifically about the refugees, but they are a theme that runs through all of what we have been talking about. Of course, 80% of Gazans are refugees or descendants of refugees from 1948. So the world is at a watershed moment, and it's a clash between a rules-based or a law-based order, where the rules are being set by a handful of powerful individuals and states at the expense of global consensus-based international law and practice. There's no doubt that the delicate scaffolding of international law built over the last several hundred years is being dismantled rung by rung. I want to discuss the major pieces of this scaffolding, the forces at play in dismantling and reinforcing them, and some considerations on where we go from here. It's worth considering that these are neither abstract nor concepts that are confined to the Israel-Palestine conflict. Whether international law has any remaining relevance is a critical and urgent issue for the rest of humanity. So starting with the law, contemporary international law relating to human rights and armed conflict rests on a number of core treaties governing the rules of and in warfare and the prosecution and punishment of the gravest international crimes as part of international criminal law. The most important prohibitions and obligations in warfare are bundled into what everyone is familiar with, the 4 Geneva Conventions of 1949. And these principles are maximum protection of civilians, prohibitions against depriving them of necessities of survival, and absolute prohibitions against murder, mutilation, torture, cruel treatment, and taking of hostages. Why do I emphasize treaty rules? What's remarkable about these rules is that the 4 Geneva Conventions have been ratified by every single country in the world, including Israel and Palestine, and rest on the fundamental international rule that treaty obligations depend on the consent of state parties. States have consented to these rules. They are not being imposed from above or from anywhere else. States have agreed to them. These consensual rules are obligations and prohibitions applying to every state party now, regardless of whether any state or non-state actor abides by them. In other words, none of the prohibited acts are permissible because they have been violated by some other actor. International law nowhere permits revenge as an excuse for prohibited acts. These are universally and accepted rules of state practice. Every one of these rules has been violated, grossly and systematically violated, primarily by Israel, based on the disproportionate killing and destruction in Gaza. To set the record straight, Israel's systematic violations of these principles long predate the escalation that began on October 7th, as the United Nations has been methodically documenting year after year for almost 6 decades in the West Bank, East Jerusalem, and Gaza. One illustration of the distorted perspective between how the rules-based and legal principles apply is that while there is legitimate outrage and concern about the 240 Israelis taken hostage by Hamas, there was little focus on the over 3,600 Palestinians held in administrative detention in Israeli military prisons, in addition to thousands of other political prisoners. I challenge any one of you to know the names of any of them. Palestinian administrative detainees have been held without charge or trial, on information kept secret from them or their attorneys, and administrative detention orders renewed at 6-month intervals that are indefinitely renewable. To be sure, these also fit the definition of hostage-taking. The rules-based order seems to have eviscerated the primacy of occupation law, which is part of the 4th Geneva Convention in this current conflict. Occupation law changes what obligations apply and to whom in very significant ways between an occupying army and an occupied population. This law prohibits forcible transfers of population from within or outside occupied territory, the destruction of civilian property, collective punishment, and punitive sieges. An occupier can never acquire sovereignty over the occupied territory. And it is the obligation of the occupying power to provide food, medical care, hygiene, and other necessities to the population it is occupying. Again, in the dystopia of the current rules-based order, these legally binding principles are being stood on their head, while Israel, the occupier, has burdened the international community with the responsibility of trying to ensure the occupied Gazans have the minimum they need to survive. And the Western powers supporting Israel have set no limits on Israel's asserted right to self-defense, whether in the amount of force, collective punishment, use of siege or famine as weapons of war, or even targeting of humanitarian organizations and killing of their staff. Finally, in one of the most egregious distortions of occupation law, Palestinians who resist occupation, a right enshrined in international law, have been castigated as terrorists, a designation that is nowhere defined in international law. The final set of fundamental rules being cast aside are the obligations to prevent and punish the worst of international crimes: war crimes, crimes against humanity, and genocide, Crimes the International Criminal Court was established in the post-World War II era to prosecute on a universal basis, universal and non-discriminatory basis. UN organs and international organizations have been documenting war crimes since October 7th, and the UN Commission of Inquiry has claimed there is clear evidence of genocide, and they claimed it early on, and has called, of course, for accountability of those perpetrating it. Many human rights organizations, genocide and Holocaust scholars have also concluded that Israel is committing genocide based on the huge volume of evidence and the undisguised intent, as Phyllis reminded us earlier, of Israeli leaders and its army. The Gaza Tribunal, an international civil society initiative, brought together first-hand and expert witnesses over the course of 2 years to create a record of historical facts on the genocide through a series of sessions held between November of 2023 and October 2025. Particularly striking about the evidence presented at the tribunal sessions were highlights of unique features of the Israeli genocide compared to other recent crimes of genocide. Features that should have triggered massive protection responses, not only from the UN, but also critical non-state institutions like the medical associations. What should have been of unique concern to medical, women's, and children's rights institutions are the imposition of measures intended to prevent Palestinian births, the systematic attack on reproduction, reproductive systems, and the next generation, which have been deliberate targets of Israeli genocidal acts. Other Israeli actions that have reinforced the genocide characterization are the systematic and complete destruction of Gaza's educational institutions, also unprecedented in recent genocides. Cultural heritage, religious institutions, its entire hospital and healthcare system, and hugely disproportionate killings of civilians, including doctors, reporters, and of course, children, leading many UN organizations to say this was a war on children. Palestine has been asking for prosecution of Israeli perpetrators of war crimes, including crimes in Gaza, since 2009. By contrast, when Ukraine similarly asked for prosecution of Russian perpetrators of war crimes, arrest warrants were issued within weeks. The crime of genocide has taken center stage in the challenge over accountability, since jurisdiction over genocide as a universal crime rests not only with the International Criminal Court, but also with the International Court of Justice. The rules versus law-based battle has come to a head over South Africa's claim of genocide against Israel, Nicaragua's claim of complicity for genocide against Germany, and the advisory opinion request on Israel's policies in the occupied territories brought by the United Nations General Assembly at the International Court of Justice. In the advisory case, the court determined that Israel's entire occupation is illegal and all states must end any relations with Israel that continue the occupation. The importance of this advisory opinion can't be understated. So who are the players and what role does politics have in this very quick overview of what international law says? International law has failed to end the genocide in Gaza and the broader Israeli-Palestine conflict, but that's because the Western powers have manipulated the main mechanisms designed to enforce it. In other words, the law is not at fault, and the international legal institutions have been doing their jobs. The primary problem is the structure of the United Nations organs and the division of authority between the General Assembly and the Security Council as set out in the UN Charter. The 193-member Assembly represents the vast majority of the countries of the world, but also the majority of the peoples of the world. In contrast, the 15-member Security Council permanently represents only 3 Western states plus Russia and China, as well as 10 other states that do not have veto power and sit on a rotating basis. Time and again, a single member of the 5 powerful security member states has defeated the will of the majority General Assembly states in refusing the global demand for a ceasefire in Gaza. Under the UN Charter, only the Security Council can invoke its Chapter 7 authority for armed intervention to halt breaches of peace and security, and the United States has continued to use its veto power to prevent any such action in Israel. But in 1950, the General Assembly adopted a resolution titled Uniting for Peace, giving itself authority to recommend action to member states when the Security Council fails to act in situations of breaches of the peace. Though the General Assembly can and has used its authority to debate and vote on urgent matters that are deadlocked at the Security Council, like the vote for a ceasefire, the General Assembly has seemed reluctant to use Uniting for Peace to take assertive action under it. After failing to stop the genocide, the Security Council passed Resolution 2803, which Phyllis had mentioned, which approved a 20-point plan that President Trump had floated to take control of Gaza. The resolution authorized a temporary security force for Gaza, and President Trump publicized a charter for it and proclaimed himself its head. The charter makes no mention of Gaza, instead envisaging the creation of a new international organization with undefined powers to resolve international conflicts, plural. The charter identifies Donald J. Trump as having final say over decisions of the executive board, and Resolution 2803 authorizes the board only through 2027, but the plan itself contains no end date. In contrast to the UN, which is based on a charter with 193 member states, the Trump board has only 26 country members, all of whom, of course, are acquiescing to President Trump's agenda. Hungary and Bulgaria are the only European countries that have joined. The Board of Peace seems aimed at directly undermining the UN system, but with so few member states, it can hardly pretend to represent the global community, a point now the major European powers and others have been raising publicly. At the Munich Security Council conference, the European Union's Foreign Affairs chief noted the different ways in which the Board of Peace assumes more authority than it was accorded under Resolution 2803. To date, however, there hasn't been an effort to reconsider Resolution 2803 in the Security Council, and with the United States, of course, wielding the veto power, it's unlikely to revoke it, but the General Assembly, representing the majority of the people in the world, is undermined by the Board of Peace and can use Uniting for Peace to refuse to accede to it. In a parallel process, the International Criminal Court has been hamstrung also by the pressure placed on it by its major funders and the politics that the Western powers bring to bear. Without American backing at the Security Council, there will be no UN referral to the International Criminal Court. Again, the mechanisms are hamstrung by the Security Council. The United States has taken a number of measures to threaten to terminate funding of the ICC and its staff, including revoking former prosecutor Bensouda's visa in 2019, Trump's executive order imposing asset freezes and entry bans on staff of the ICC in 2020, and new sanctions imposed on ICC prosecutors and 8 judges at the International Criminal Court in December of 2025. The International Court of Justice is independent of the UN political bodies in its decision-making, but as the International Tribunal of the United Nations, it must revert to the Security Council for enforcement of its judgments. This process undermines two watershed International Court of Justice advisory opinions, and of course the ICJ provisional measures or injunctive measures that right at the beginning of the genocide ordered Israel to terminate its genocidal acts in Gaza, later immediately called on Israel to allow unrestricted humanitarian aid. Again, 4 provisional orders from the International Court of Justice, unprecedented from that court. Again, requiring Israel to cease its genocidal acts and the incitement to genocide, and to punish those who were carrying out genocide against Palestinians. Of course, the United States and Israel immediately denounced the ICJ's orders, calling South Africa's case meritless. If you read the 100-and-something page memorial submitted by South Africa, you'd have a hard time concluding that it was meritless. Shortly after the issuance of the provisional measures, Israel claimed that UNRWA staff members participated in the Hamas attack on Israel in October, and without providing any evidence of wrongdoing or an independent investigation, the United States and other major Western donors suspended their funding of the organization. Other actors in the UN machinery are similarly powerless to do much more than issue reports and conclusions. Critical as such reports and conclusions are in reinforcing and confirming what the law is, no other organ besides the Security Council currently has an immediate mechanism to enforce them. So the last and most important set of actors that I'm going to highlight are national governments and courts, and all of you, civil society. The governments of South Africa and Nicaragua have taken the lead in filing genocide and complicity to genocide claims at the ICJ and have been joined by scores of countries in their applications. At the national level, legal groups have filed cases in the United States, in the United Kingdom, in Germany, the Netherlands, Spain, Portugal, and many other countries against Israeli perpetrators and corporations complicit with the genocide. The struggle between international law and Western hegemonic rulemaking is now in the balance. These 3 major groups of actors will determine the outcome: the UN's General Assembly, national courts, and civil society. The General Assembly can use the Uniting for Peace resolution more forcefully. It could organize a peacekeeping force to enter Gaza to protect the population. It could ask member states to contribute soldiers. It would not be, by the way, the first time Uniting for Peace has been used to keep the peace in Gaza. In 1957, the General Assembly, acting under Uniting for Peace, dispatched a peacekeeping force to the armistice line separating the Gaza Strip from Israel, the very line that Hamas breached in October of 2023. The UN force remained for 10 years, until 1967, when, after Egypt requested its withdrawal, Israeli forces overran its positions, killing 15 of its personnel in the process. But the United Nations has experience sending forces into many situations of active hostilities, and the General Assembly can do it. Amidst widespread public opinion that Israel has been committing genocide against the Palestinian people, so far, despite warrants issued against them, the perpetrators remain unpunished, and a nominal ceasefire provides cover for this genocide to continue. The ongoing Israeli genocide illustrates the failure at every level of an entire global system intended to protect civilians. That's what all the law is about, protecting civilians. While civil society around the world has protested, marched, joined flotillas to break the siege on Gaza, and has sought by all means available to hold the perpetrators accountable, the global political and privileged class has circled the wagons to protect the profitable ties to the Israeli genocide machinery. Powerful institutions, from universities to medical to legal to women and children's associations, responded to the genocide with silence, or worse, suppression of the facts and attacks on those bringing the facts to light. The weakness of the United Nations in enforcing the incredible International Court of Justice orders heightens the need for civil society to continue and increase its role. The existence of the ICJ orders is a powerful tool in pressuring governments. It is the foundation for all of our work, because law applies to all of us and binds us all. Once the International Court of Justice said that prima facie evidence showed that Israel was committing genocide, the narrative about Israel's incursion into Gaza changed dramatically. Domestic lawsuits, following the precedents in the United States, Germany, and the Netherlands, are likely to grow. They are growing, along with the protest actions of millions of individuals. Future peace is in the balance, and it cannot be left to a tiny minority of global actors to determine the outcome. Law is an important foundation for all of our work, but the rest of the work belongs to us. Thank you.